We are here for the beginning of the trial in State versus Janet Hugo. The state filed a motion in limine with the court this morning regarding a couple of issues. The motion in limine essentially seeks to preclude Ms. Hugo from raising certain issues. One being the fact that I denied you court-appointed counsel. You did mention that at one year, that should not be something that's addressed during the court proceeding during the trial. Do you agree with that?
Yeah, that's fine.
The state also mentions my order on the motion to dismiss, essentially arguing that on its face, these statements did not as a matter of law constitute a threat. What they're asking me to order you is that you not get up and say, I filed a motion with the judge, and the judge said it was your decision. Another part of that motion, as I recall it, was an argument that the statements were protected by the First Amendment. The state thinks you should not be able to argue that it was your First Amendment right to speak the way you did. Why shouldn't she be allowed to say she believes she had a right to say these things?
The jury is not here to decide constitutional issues. And I don't think that an instruction fixes that. I mean, this was a question of First Amendment concerns during the motion to dismiss, not here. This is a trial at which the facts and the evidence will be considered by the jury, but not issue of constitutional law.
So listen, when I wrote that post, in my head, I really figured I have the First Amendment right and the freedom of religion, because the post, when I break it down, is going to show that I'm a practicing witch, and then I based it on karma. Everything I said has been on karma. It was never a true threat, and that's the other thing about the First Amendment. In order to prove the First Amendment that I was wrong, this actually has to be that it was a true threat to these people, that their lives were unfair, that they made changes in their lives. And they didn't. They already admitted to that. And that's going to be part of my argument.
I should say too, Your Honor, that ignorance of the law is not a defense. So the defendant's mistaken belief, assuming that's what the jury decides, that she has the right to vote whatever she wanted, is not a defense.
Whether it is or it isn't, maybe could be a jury question. But what if that is a genuinely held belief that she, as a matter of my religious practice and belief, I can say these things because I'm not threatening anybody, or as a matter of my right to speak freely. You just don't want her to utter the words of the First Amendment.
Not from the jury's fact-finding perspective. And to then issue an instruction that corrects that misimpression is sort of, why do it to begin with?
That day, I know what I said. I know how I felt, and I know what was in front of me. I know what was in front of me, and the AG's office called me the next day, and I explained it to Dick Tracy exactly what was on that. I'm going to give you the CD to go listen to it in the back room, because that is going to be part of my defense. They knew what I meant. The state senator did the exact same thing. She wrote it up on Facebook. She said, I think the President of the United States should be assassin. Somebody told her to take it down. She took it down. The Secret Service, not even the state AG, the Secret Service investigated this woman and did nothing because they said it was her First Amendment right and she had taken it down. It's the same thing with that Kathy Griffin woman holding the president's head. These people aren't facing felony charges. And you know why? Because they were all saying it was a First Amendment right, freedom of speech. Hey, people may not like what everyone has to say. I said it out of hurt. I said it out of pain. I said it out of anger. Because no one wants to speak about what is really going on and what really happened.
It turns out that the AG has a different opinion about the meaning of these words. You say they're a threat. You can ask the jury to find that they're a threat. She says they're not. But she understands that she doesn't have the right to threaten. Isn't that what she's saying? I just didn't think that's what it was.
Regardless of what she's saying, an exposition on the First Amendment during her testimony is irrelevant, inadmissible, and prejudicial. So position of all defendant, and were irrelevant, inadmissible, and prejudicial. So our position is simply that the first discussions of the First Amendment are not the jury's purview, and it will be confusing and misleading, and we're going to litigate the contours of the First Amendment, which was done during the motion.
That's where you lose me, the contours of it. The contours are very simple. You either have a right to make a threat or you don't. The state's position is that was a threat of violence. Her position was it wasn't a threat of violence, and therefore I had a right to make it.
We're not here to decide whether or not she had a right under the First Amendment. That's not what the instruction will be. The instruction will be here the elements of the offenses of certain threats against government officials and criminal threats. That is what we want to decide. If you introduce the First Amendment to these proceedings, it will be confusing. It is not an element of the crime. And I implore the judge not to allow this to happen.
Is it your view that she is allowed to talk about what her religious beliefs are and what she intended when she made this statement? Not a true threat of violence,
Yes.
that wishing for harm on somebody.
Yes.
But she can't go on to say, and that religious belief and practice is protected.
That's right.
She can't say that.
No. No.
I just don't understand why not.
The backdrop of the Constitution, the statutes, the rules of evidence, that is not for the jury to be concerned with. They are concerned with the facts and only the facts.
All right, I'm going to take a minute to think about that issue, and I'll let you know before the jury comes in, which is going to be a while from now, the way things are going. So the next issue is her explanation of her own diagnosis. I think she said PTSD.
I got that motion yesterday at 3 p.m., so I wasn't able to clear it with them.
But you do not intend to say to them that you have been diagnosed with PTSD.
No, absolutely
or that
not.
you have parental alienation syndrome.
I didn't say parental alienation syndrome. I said the term parental alienation.
No, that's right. So you're not going to be testifying to them that you have those things.
Oh, no.
Right.
And who is aware of the term parental alienation? Because when it comes to Judge Weaver, that whole court thing was about parental alienation. They say it doesn't exist, but the New Hampshire Supreme Court recognizes parental alienation. I just want to be able to question and talk about it. That's it.
The New Hampshire Supreme Court talked about parental alienation and not parental alienation syndrome.
That case had to do with the effect of parental alienation on the children, not a parental alienation syndrome that may have affected the parent.
So long as there won't be testimony about diagnoses and syndromes.
Well, she agrees that there will be, so that motion is granted, and there will not be discussion of those issues. All right, very good, and I'll see you back here in about 10 minutes.
All right.
The stress.
Yeah.
This weekend.
All right, we have a report.
Before the jury comes in, I wanted to give my ruling on the state's motion that we go from characterizing her belief about her statement as protected by the First Amendment, either as a matter of free speech or religion. I am going to allow her to describe it in that manner, simply because Ms. Delfico may utter the words of the First Amendment and that her conduct was protected. I don't see that as particularly confusing to the jury. I'll be instructed on the limits of both First Amendment speech and religion. So go ahead and bring in the jury. We'll have them sworn, and the charges will be read.
All right, jury entering.
Good morning, ladies and gentlemen. First, thank you for your patience this morning.
Members of the jury, I will now read you the charges that Janet Delfico was on trial for. The first charge ID 1457071C, and this charge reads that Janet Delfico, on or about February 5th, 2017 at Northwood, did commit the crime of harm or threats to certain government officials, and that Janet Delfico purposely threatened to commit a crime against a member of the judiciary in retaliation for action taken as part of that official's government duties, and that in statements Janet Delfico posted on Facebook, she threatened Judge Mark Weaver of the New Hampshire Circuit Court in saying, post number 1, quote, "As my aunt just asked me, are you really going to be able to live with yourself with all the pain you are causing your family?" My response was yes. Let them all die and suffer. Hear that, Diane? Suffer. End quote. Post number 2, quote, "The judges and that fucking attorney are so next. So next." End quote. Post number 3, quote, "Donald, dead. Mother just lost it all. Diane sick. Husband sick. Next is Weaver, Anderson. And gallant, I will keep this shirt off my back and heal your diseases, but I am also just as capable of killing you off. Don't ever cross me with corruption and greed." End quote. The next charge on D. Did commit the crime of harm or threats to certain government officials, and that Janet Del Fuego purposely threatened bodily injury against a member of the judiciary. The third charge on D. Did commit the crime of harm or threats to certain government officials, and that Janet Del Fuego purposely threatened bodily injury against a member of the judiciary. The next charge on D. Did commit the crime of harm or threats to certain government officials, and that Janet Del Fuego purposely threatened to commit a crime against a member of the judiciary. And the final charge, did commit the crime of criminal threatening, and that Janet Del Fuego threatened to commit any crime against the person of another with a purpose to terrorize any person, and that in statements Janet Del Fuego posted on Facebook, she threatened attorney Clifford Gallant in saying, now, ladies and gentlemen of the jury, the defendant has been arraigned on these charges, and she has entered a plea of not guilty.
Thank you, Madam Clerk. So if you could, you may be seated. This time, we're going to hear the opening statement of counsel, so please pay careful attention. Say it.
Let them all die and suffer. The judges in that fucking attorney are so next. Next is Weaver, Anderson, and Gallant. I will give you the shirt off my back and heal your diseases, but I am also just as capable of killing you off. That is the threat that the defendant, Janet Del Fuego, posted on her Facebook page. The defendant made these Facebook posts on February 5th, 2017. Now, you're not going to hear that the judges and Attorney Gallant were tremendously fearful of the defendant's post. But you will hear that they were concerned and that they understood them as threatening. When the defendant posted those threatening statements on Facebook, she did so with the purpose to threaten to commit a crime or bodily injury against Judges Weaver and Anderson in retaliation for action that they had taken as part of their government job, and with the purpose to terrorize Attorney Gallant. That makes what the defendant did on February 5th a crime. As against the judges, that crime is called harm or threats against certain government officials. And as against the attorney, it's called criminal threat. And those are the crimes that we will ask you to find her guilty of at the end of this trial. Thank you.
I almost started crying again. Hearing those charges, I remember that day. My ex-husband was homeless when we got divorced. My children were visiting him in a camper in a campground. I felt sorry for him. I wanted to be the better parent. I gave him an equity loan off my house. He bought a mobile home down the road so my children could have a safe place to visit him. My number one rule for my whole divorce was keep the divorce out of my family. I brought up the term to you, parental alienation, and asked you if you knew what it was. Parental alienation right now is a hot topic in the state.
Objection, Your Honor. I thought I was allowed to talk about it.
So that wasn't the scope of my ruling,
Okay,
so you could move on.
so don't say it.
Thank you.
Things happened with my children and my ex within the court system. Things I never saw coming. I raised my children by myself from the age of 5 and 7. All of a sudden, at 11 and 13, I was being dragged into court and being told I was the worst parent on the face of the earth. I get a little emotional about this. 5 years later, I'm still emotional. An emotional mom, an emotional Italian. This is real, color out the gray, redhead mom. A mom who is a practicing witch. That's what that post meant. I'm capable of killing you off. It meant karma.
I'm not even sure what she's showing.
Oh, yeah. You're gonna say I'm evil, I'm hideous. I'm not. I believe in God. I go to church with some of my hospice clients. Killing you off meant your negativity that you have created to me on so many levels. I ended up going into civil court because it kind of blurred. That's my house. This is my home. I bought this house the day I found out I was pregnant with my youngest in 2001. Okay? I did all of this. This was a certified junkyard. I planted every blade of grass, every flower, every tree. I was now fighting to keep this house for me and my son. As far as the equity loan goes, I won that. His house was sold. The money was paid back to Granite State Credit Union. It was removed. I'm angry at the Glen office law firm because of what they did to me. They made me refinance with them at a higher rate. At a higher rate, 6 months later, after the equity loan was given and my ex-husband paid, they knew exactly what was going on. I'll question them on it. I went from a 2.8% 9-year loan that I could totally afford and be happy with to a 6.75% loan on 15 years that I can't afford. So I'm barely holding on. That's why I tried suing them. But at the same time, they tried suing me in Superior Court. And again, I won. I won to remove every Facebook post and video. One of them, I think they're going to show, with Senator Kevin Abard about the whole story. They tried suing me to take down everything. They didn't want anyone to know. I wasn't doing it out of revenge. I was doing it because I didn't want anyone to be stupid. I didn't want anyone to follow my footsteps. Forget about when everyone tells you to be the good, better parent. Step up. Step up to the plate. Be the better parent. I stepped up to the plate. Look where I am right now. Did I write some really bad Facebook posts? Yeah, I did. Was I in the middle of watching my 2 children that were best friends be torn apart? Yeah, I did. Did I cry every night? How am I going to support a house as a single mom? It's only me. Yeah, I did. Did I know that when I wrote this post, Granite State Credit Union hired an employee to watch my Facebook page every single moment, including on their weekends, every 15 minutes to see, because they knew I had broken at that edge when that final decision where I wanted to sue Granite State Credit Union for predatory lending was thrown out? Yeah, I did. It was done. It was over. They saw it. They immediately took it, screenshot it, and took it to the AG's office. Did the AG's office know about all of this? Yeah. See how many complaints I filed to the AG's office about the banking and overruled?
Not too far.
Okay, sorry. They saw that day. The next day I got a phone call from the AG's office, Dick Tracy, asking me what it meant and where it was. I informed him. I took it down 2 hours after I posted it. I calmed down. I knew it was wrong. Knew it was wrong. I thought that was the end. It was over. Okay, I apologize. I'm sorry. It was wrong. I got over emotionally. You know how I've been through this whole process. I wasn't a one-time thing with the AG. A year later, I'm nailed charges. 4 felony charges. What's that? It's how it happened.
Yeah.
Overruled.
Yeah, go ahead.
So a year later, stuff started happening. Things started getting redug up. As I was healing, everything was brought back out. Another year and 3 months, here I am today. I'm gonna leave it up to you. They kept saying everybody was a victim, a victim, a victim, a victim. There was more than one victim. I was the original victim, me. And they said over and over again that I'm going to kill. They kept highlighting kill, kill, kill. It was never kill, kill, kill. I wasn't gonna go kill anybody. I wasn't gonna hunt anybody down. But I was gonna set up crystals throughout my house. I was gonna set up curses. I was gonna remove all that negativity away from me that was considering eating me, my physically and mental and emotional being. And I was gonna kill you off. And that's what that post meant. I named my uncle and my sister in there because they were part of the parental alienation of the family law court part that I had going on. People that didn't even know me. This was about me, my children, and my house, and raising good boys in a stable, loving home where negative energy and negative people were coming in and trying to destroy our lives. That's all this is about. This is about a state that wants to change everybody's opinion of a mother that got hurt so deeply and so badly that I'll admit it. I'm never going to overcome this. Never. Thank you.
Thank you. State claim first witness, please.
And would you kindly state your name for the jury, please?
Jody Duchesne.
You swear that the testimony you're about to give to this jury will be the truth and the whole truth and the truth. Please be seated. That chair does witness station. And a larger microphone in front of you, amplified.
Good morning.
Good morning.
Would you kindly state your name for the jury, please?
Jody Duchesne.
Why is her opinion relevant, especially since I've excluded any other witness from giving an opinion about these things? She's not the victim, and neither is the bank.
Frankly, she probably could have been a victim in the case, and a charge could have been brought naming her. But regardless, she is the one who first discovered the post and then provided them to the attorney.
Whenever she posted about, hold on, whenever she posted about the bank, it went to her higher ups.
Our understanding is that she kept the files and she provided them to us when the investigation began. Ms. Duchamp, where do you work?
At Granite State Credit Union. I was the marketing manager there.
And that she was ordered and paid to monitor my Facebook page every 15 minutes.
Did you screenshot those Facebook posts and save them as you described?
I did.
States 2A.
Rockingham Superior Court with Judge David Anderson, Janet Delpico versus James Goad. Mr. Goad committed bank fraud right along with Granite State Credit Union. This judge has done nothing to help but made it worse. There are more videos and theories on YouTube, corruption at its finest, share, and show just how bad our system has become.
States 2D.
That is a me that says, hello, stalker, I'm joined fine, thanks for checking up on me.
States 2C.
When I say something, you better remember two things. One, I mean it. Two, I will act on it. When I say it, it's a warning, not a threat.
States 2D.
This is a picture of Granite State Credit Union's attorneys. Clifford Gallant is the one on the end in the blue shirt. Why is this important? Not only on my page is the judge ordering them to hand over all paperwork from Granite State Credit Union, I now have in my possession of him telling me, no, they won't hand over nothing.
States 2E.
That is a memory that was shared.
States 2F.
Has anyone ever wondered that maybe I post stuff and say stuff to screw with your tiny idiotic brain? No. Someone shared that link to the credit union's website, and within that post there were threads.
Okay, thank you for that.
And within that post there were threads. And within that post, there were threads.
Okay, thank you for that.
All right, ladies and gentlemen, so the witness just made a comment that to the effect that in the post there was a threat. You are to disregard that comment. It has no relevance to this case whatsoever. Her opinion about whether it constitutes a threat or not, that's right now, that's substantive evidence for the jury to consider. Right now, that's substantive evidence for the jury to consider. I'm not convinced that it should. But the jury is going to be allowed to say, well, there was this woman from the bank who's not a victim, who thinks it's threatening. We'll take her opinion into account. I'm going to allow that. Shouldn't I allow other people to say, well, we know Janet. She would never intend anything like that. We read these texts and we don't think they're threatening.
Well,
Shouldn't I allow that? Just
the difference is that the defendant's friends and supporters had no business, were not involved in litigation between the credit union and the defendant. So I think the answer is no, they are not similarly situated.
She saw that post at the exact same time. She saw the post. And so did the other people see the post. And they all had their opinion. So you're right. She's given her opinion, but yet my friends, they can't give their opinion. They were witnesses too. They weren't part of litigation. She's not part. Nobody was part of litigation. It was just open social media.
the witness described her opinion about the tone and the intent of the post. That's her opinion about that is only to be used by you to explain why she took the next step in dealing with that post. It's not to be taken by you that as evidence that the post was aggressive or threatening.
At stage one. So what did you see first? Can you describe what you saw when you looked at the Silver's Facebook page? That what time of day was it?
I believe, and I'm sorry, it's been a number of years, I believe it was probably around 1:30, 2 o'clock in the afternoon, but I could be wrong on that. Want you to read that?
I think the jury has heard it and they can see it. Can you explain the first post versus the second, and sort of how the mechanics of that would work on Facebook?
So initially you have the first initial post, and from there would be what we call a thread. And I think you misunderstood me earlier. I didn't say the word thread before I said the word thread. And within that post, there were threads.
You said on one of the interviews, okay, they asked you how many times you monitored my page, and you said several times a day, even on the weekends. Did you have any other job at Grand State Credit Union besides monitor my page all the time?
I did. Right. The reputation of the credit union is one of the key roles that I have at the credit union. I get Google alerts and
Google alerts. Can you explain what that means?
anytime Grand State Credit Union, that name, it comes up, you get pinged, and then you can see what that was in regards to.
How many times a day is that?
Once or twice.
That's not several. You said several times a day, even on weekends.
So it's twice a day. I mean, there was no set standard there.
So this was in 2016. At the top, it says Psycho X. Are you the X? Am I missing something here? I didn't think that was your ex. I don't know you. But
That's an additional question.
Well, the question was, did you believe that post about Carlos Lopez was directed at you?
I wasn't sure who it was directed at. I captured it because I felt that it might be indicative that she was aware people were reading and monitoring her Facebook posts.
All right, thank you.
Thank you.
Thank you.
Thank you, Your Honor.
State, want to call your next witness?
Yes, the state calls Attorney Felonies.
Good afternoon.
Could you introduce yourself to the jury, please?
Yes, my name is Clifford Paul Gallant, Jr.
You swear that the testimony you're about to give to this jury will be the truth and the whole truth, and nothing but the truth. Please be seated.
Good afternoon.
Good afternoon.
Could you introduce yourself to the jury, please?
Yes, my name is Clifford Paul Gallant, Jr. I'm an attorney with the firm of Bella Wilford and Gallant. Our firm does both representation of the creditors in the areas of real estate as well as creditors' rights. I was first advised of Ms. El Fuco as a result of a series of appearances on local broadcasts in which she was making certain assertions about our client pregnancy credit. So as a result, we filed a complaint in the Rockingham County Superior Court to get something known as injunctive relief to record Ms. El Fuco to discontinue those communications.
And you said that during that hearing, you wanted restraining order, quote unquote. What was restraining order action going to be for? Because
The question is, what was?
they were trying to get a restraining order. For
Right,
what?
You're asking for what?
For what?
And what's the objection?
Well, the objection is the characterization, but also he's testified to it.
Well, not a process.
What was the restraining order for?
We were looking for an injunction to enjoin you from We were looking for an injunction to enjoin you from continuing the conversation that you were engaged in about the credit union. Specifically, two separate interviews. One was with, I think, a fellow by the name of Kevin Avard out of Asheville, and the other was a fellow by the name of Michael Gill.
You actually just said fellow Kevin Avard. Let's not call Senator Kevin Avard a fellow.
Right, hold on.
Objection. Well, you're making it sound like I was objection to anybody. Was there any other restraining order issued for anything else, or was it just to take down all these informational videos that I was asked to do?
Mr. Fuco, Judge Anderson denied our request for injunctive relief.
What was Ms. Del Fuco's demeanor at that hearing?
They agitated and angry.
Now, are you aware that there's not just a equity loan on my house, that there's a credit union also has a mortgage on my primary home?
Objection.
My understanding is that Ms. Del Fuco had obtained a loan, which is a home equity loan, which they pledged a second mortgage position on the property. I believe it was in Northwood as collateral for promissory note.
Mr. Gallant, you want to go into detail about what happened with the equity loan application and why you were so reluctant to give me any of that information?
I certainly am aware of the fact that you were involved in litigation with your husband.
Excellent.
And you were looking to get information having to do with the origination of that loan obligation.
Why was I looking for that information? Objection.
So
My ex-husband took out the loan with the credit union. By law, I should have seen all of the paperwork. Some of the signatures on this paperwork I never saw or signed. I only signed one page. Remember that?
do you understand that that was the reason she was asking for the paperwork?
Your Honor, I understand that there was something known as a right to cancel, notice of right to cancel, that she had executed in connection with that loan obligation.
Okay, since we can't remember anything about the agreement, let's go with the lawsuit.
Objection.
I can't objection.
Hold on. That comment, sir.
What was I claiming in the lawsuits?
Mr. Duffy, going on honesty, those complaints were long and rambling, and
Long and rambling, excuse me?
they were.
With regard to the litigation in the case of Granite State Credit Union versus Angela Fuco, what happened next?
The court entered an order denying the request for the injunctive relief.
So you lost that case.
That is true.
And what did you do as a result?
We dismissed the case without prejudicing the right of the credit union to bring it back if it felt necessary to do so.
Okay. And what about Facebook posts? Did you also aware of Facebook posts?
There were Facebook posts that were also made by Ms. Del Fuco that were not favorable as to the credit union.
Let me show you what's been marked for identification. It's one. Mr. Gallant, what is that?
Facebook post by Ms. Del Fuco.
What were your thoughts as you read those posts?
I certainly was concerned. In all my years of practice, I've never had any such assertion be made against me by anybody.
How did you receive the language in this case?
Threatening.
What did you do?
The next day, I had a meeting with one of my partners, Attorney Richard Fredette.
So I don't have any further questions for you.
So you saw this post and you took it as a threat. What
Yes,
do
ma'am.
you, right?
Yes, ma'am.
What did you think was gonna happen to you when you actually read that post? What was going through your mind?
I didn't know what you were going to do. I didn't know what you were going to do. As I testified, Ms. Del Fuco, I've been practicing law at this point for 31 years. I've been in a lot of courtrooms and a lot of different issues having to do with representing creditors. And I understand that folks in that situation can get a little agitated. I will tell you that the way that you reacted, and especially with that post, in my estimation, that went off the charts and that caused me real concern.
If this was such a threatening post, what action did you take against me during any of this time?
Ms. Del Fuco, what we did was we proceeded.
This was the worst, absolute worst, threatening post on the face of the earth that you have ever seen. My God, if that was me, I would have gone and taken out a restraining order. Did you take out a restraining order? You was a bank?
Let him answer the question.
Ma'am, I did not seek a restraining order.
Thank
No.
you. I'm all done.
Thank you, sir.
We have no further questions. Thank you.
Thank you, sir. You swear that the testimony you're about to give to this jury will be the truth and the whole truth under the penalty of perjury. I do. Please be seated.
Would you say your name is
David Anderson. I'm a Superior Court judge.
Ms. Del Fuco, Jan Del Fuco was a party in a series of cases over which you presided, right?
Yes.
Can you just look at these dates and run through them and tell me how many times you saw me in court after that and made decisions?
So this would be after February 2nd.
After you saw the post, how many times you saw me and made decisions?
So I were made decisions.
Yeah, both, please.
A lot.
A lot.
What were your observations of Ms. Del Fuco's behavior in court?
She felt very strongly that she had been wronged by both Mr. Goad and Grant State, and so she would sometimes in court be very upset about that fact.
I'm going to start with Jan Del Fuco versus James Goad.
Ms. Fuco filed a complaint against Mr. Goad. She was seeking enforcement of an agreement that she alleged existed between her and Mr. Goad that required him to pay her $500 a month so long as a certain loan remained unpaid. And the loan was a loan that allowed Mr. Goad to purchase a manufactured house, and she had agreed that the house that she owned at that point could serve as collateral for that loan.
How did you rule with regard to that request?
I ruled in her favor.
The second case is Granite State Credit Union versus Ms. Del Fuco.
The Granite State filed a suit preventing Ms. Del Fuco from continuing to make what they viewed as defamatory comments about the bank.
You denied them the relief they requested.
Yeah, I think I had a hearing. At the end of the hearing, I issued an order in Ms. Del Fuco's favor by, basically ruling that bankruptcy was a prior restraint on speech, which is something the First Amendment protects against.
I'm going to move on to the last case involving Ms. Del Fuco. How did that case start?
She filed a complaint against the bank. Granite State Credit Union filed a motion to dismiss.
Do you recall who represented the credit union with regard to that case?
Attorney Gallant.
What did you rule?
I granted Granite State's motion to dismiss.
Okay.
It was under the doctrine of res judicata. So if you subsequently file suit on the same subject matter, you are prevented from doing so. You can't bring any claims you did bring or could have brought in the prior action.
You say in your order, the court sympathizes with the plaintiff's current situation, the plaintiff being Ms. Del Fuco. Why not just order that the home equity loan be removed?
Because I'm constrained by what the law allows me to do. I mean, if a complaint doesn't state a claim under the law, I have to dismiss it. I can't say, well, I don't like this plaintiff, so I'm going to let this claim go forward. If it doesn't state a claim under financial law, it has to be dismissed. But, I wrote that because I knew she felt incredibly strongly about all of these issues. And so I wanted her to understand. I understood what she was frustrated by. I understood what she was feeling about all this, and I wanted her to know that notwithstanding was dismissing the counterclaims was either because of racial or because they didn't say it.
When did this self-imposed next come to your attention?
Several days later, but less than 2 weeks later, I had received an email from an attorney who's a friend in Portsmouth, and he had, I think, been in touch with Attorney Gallant, who had made him aware of certain Facebook postings that Mr. Felonies had made.
Okay. And how did you perceive that statement?
I wasn't sure how to perceive it. I don't think it undermined my thinking going into this that she was dangerous, but the language was concerning.
Okay. What were you concerned about?
Well, using the word killing me off, so there's a safety concern
There was a safety concern.
that comes about when you read it. I didn't view her as being dangerous.
This was different?
The text, the Facebook posts were a little bit different.
Yes. Okay. What did you do after you read these posts?
I did two things. So I had forwarded that PDF to two people, Jason Jordan Hazy, who heads up security for the courts, and I sent it to Judge Weaver, who I didn't have any reason to think he had seen this before, so since he had mentioned, I thought he should know about it too.
Sorry, go ahead.
I think I sent him in the email to Judge Weaver. I didn't think she was dangerous, but here's this communication you probably ought to know. That was the gist of the email.
Sure. What is your recollection on why we're here today?
Objection, Your Honor.
I want to know what he really feels why we're here today.
Objection.
We're here today because of the charge.
That's overruled. You go ahead.
We're here today because I've been charged with criminal threatening, correct?
I don't know what you've been charged with.
That's what I'm going to see.
Right.
I've been charged with criminal threatening.
Objection.
Even after this, do you feel I am a threatening person?
I didn't feel you were threatened.
Okay. And am I the first person that's ever gotten a little emotional at court?
Objection.
Overruled.
Okay, well, I think I got my point there. You do not think that I was threatening. You didn't take a restraining order against me. You didn't go out buy a gun for self-protection. You didn't do anything. And you saw me afterwards numerous times and made numerous decisions on the cases, correct?
Correct.
Thank you.
Thank you. Any redirect?
No.
Thank you, Sue. All right, ladies and gentlemen, given the hour at being almost 4:05, we will suspend for the day.
What happened between me and my oldest son and my ex-husband, let it rest. That is what set me off. And he looked me right in the face the very last hearing. And he looked at me, he goes, "You're a bad hearing." And that's when I stormed out of the courtroom and I never went back. After everything I did, I went back in that hearing, he said, "I can't even handle it right now." And I went to Glasgow, and that's where I went to all the parental alienation, and that's when I walked out. I realized how dare you people, the court system allow that crap to happen to my children.
The specific contradiction doctrine allows the admission of otherwise inadmissible evidence, and so the fact that if some of it is hearsay doesn't matter. The defendant says that evidence has nothing to do with the charges. We did not want to go down this road. Ms. Delfico chose to go down this road. She made it a part of these charges. But Ms. Delfico is intent on establishing that Judge Weaver and Judge Anderson were wrong. So it opens the door to that testimony and opens the door also because her argument is that Judge Weaver's orders were unfair and perhaps unlawful. they weren't. I mean, he made specific findings about her behavior.
Half of the reason why I was so upset with Judge Weaver all the time is because he wasn't listening to me, and he was being given motions that I never saw. So this is all irrelevant about me and my oldest son, because it's hearsay, all of it. And we're only supposed to be here today with these charges stating that I made a threat, I made a post.
The state's motion to broaden the scope of the testimony of Judge Weaver to include his findings against Ms. Del Fuego is denied. In my view, this is not specific contradiction, although Ms. Del Fuego made some statements about her opinion that she was the better parent and that this should not have been happening. In my view, that does not open the door to Judge Weaver expressing his opinion based on what he saw and how he crafted his orders.
What do you say your name for the jury, please?
Mark Weaver,
What do you do for a living?
I'm a judge. I was nominated as a special justice to the district court. And then in 2012, I was nominated as a full-time justice to the circuit court. The circuit court was created by the legislature, I believe, in 2011. What it did was it combined three prior courts, the district court, the probate court, and the family division, which handled all divorce cases, custody cases, and such, and combined all three into a single court. I can hear cases ranging from criminal cases, small claims, landlord tenant cases, all district division, probate cases involving trusts, wills, and probates of the states, adoptions, abuse and neglect cases in the family division, termination of parental rights, divorces, parenting rights.
How do you know the scope of your authority as a family division judge?
It's set by statute.
Are you familiar with Janet Del Fuego?
Yes.
How are you familiar with her?
She was a litigant in a case before me in the family division.
I want to move on to a pleading that Mr. Goad filed. What did Mr. Goad ask for with regard, in particular, to visitation?
He wanted full custody of both children.
Okay. Did Mr. Goad's motion include allegations about the defendant's conduct?
Yes.
Did Mr. Goad's motion include some of Ms. Del Fuego's Facebook posts?
Yes.
I'm going to show you what's been marked for ID as State 7. Judge Weaver, can you read that from where you are?
Okay. What it says is my ex-husband will go to the New Hampshire court system. At least I have balls and don't need to suck balls. Fuck you. Say 461-A:11. You should be so happy I was treating you like a man and not a pussy. Don't worry, Jim shapes it all. His arms, legs, all of it. So suck him.
RSA 461-A:11, just remind us what that is about.
That's the statute that sets the standard for when you can modify child custody.
There are 2 pages to that post, so I'll put up the second.
As I swear any guy that can lie right through his teeth and smooth over a judge is blowing me.
What did you order with regard to Ms. Del Fuego's visitation with her older son?
I have suspended it. In this order, because it's the ex parte motion, was based solely on what was in this document. After this order issued, then it would have been scheduled for a hearing
I see.
on the motion, on the ex parte motion. I basically continued what I'd already ordered in terms of suspending her time with the older child.
At that hearing, did your order remind you whether or not Ms. Del Fuego admitted to posting the pornographic post?
Yes, she did.
And again, what authority did you have to suspend Ms. Del Fuego's visitation rights with her older son?
Again, this was under that same statute that allows for modification of parenting rights. Her visitation was suspended, and she was prohibited from initiating communications with her older son.
Okay.
At that hearing, she left before the hearing was done, and raised her voice, and she was yelling at me.
she yelled at you? Did she lose control?
Yes.
Okay. I want to move on to the Facebook post that bring us here today. What was your reaction?
Slightly concerned.
And what language in the post was concerning to you?
Well, where it starts with the judges and an attorney or so next. And then the Donald dead, mother just lost it all, Diane's sick, husband sick. Next is Weaver, Anderson, and Gallant. That's what concerned me.
Why did it concern you?
Well, I took that as a threat.
Okay. What did you do as a result of receiving this post?
The first thing I did was touch base with Judge Anderson to let him know I got it. And I also touched base with the clerk of the court and the court security to make sure they were aware of it.
Mr. Legal cross-examination.
You're not the one that actually issued the divorce. I was actually divorced before you saw us, correct?
Yes.
And who had custody of the children?
I believe they're both residing with you at the very, very beginning.
After everything was said and done, okay, I was able to see my son. If he wanted to talk to me,
Testify objection.
Go ahead. At the end of that part I testified to was if he reached out to you, you could communicate.
and he could do that, okay. And who did I have custody of? Did I not have custody of one of the other children?
You had the younger son.
I had the younger son. I had custody of the younger son. Did you have people come in and testify on my behalf stating that everything was fine until that equity loan was taken out on my house? Do you recall that?
There was a hearing where you had several witnesses, and I believe one of them did testify something to that effect.
Said that you couldn't even believe we were divorced, we went to marriage. I'm refreshing his memory.
Injections.
Okay. Did anyone put me down or even put Mr. Go down because even though they were my witnesses, they were familiar with the both of us, correct?
Here's that.
Well, he heard it, he's a judge.
Hold on. That's the same question from one person.
Was there any extra security in the room?
The room is monitored both by an officer in the courtroom, and there was an officer in the control room monitoring it both visually and audibly.
But there was no one extra in the
They
courtroom.
were right outside the courtroom, so that if something happened, they would radio them to come right in if there's anything.
Was there any scene?
No.
Everybody was totally okay?
Yes.
You said that I got up and I walked out.
Yes.
Why did I get up and walk out?
You were very upset and you
After
turned around and walked out.
I went into details about things on how upset I was at that particular hearing, correct?
Correct.
What did you say to me? That right before I started packing up my stuff, what did you say to me when I got up and left?
I honestly can't recall.
You said you're a bad parent.
Does that refresh you?
It doesn't.
I'm done.
It doesn't sound like something I said.
Thank you.
Thank you. And any redirect?
You said you have no recollection of calling yourself a bad parent, and it's not something you would say.
Correct.
Thank you. I have no further questions.
All right, thank you. Any recrossing? Thank you, Mr. Mason.
Thank you.
Do you swear that the testimony you're about to give to this jury will be the truth and the whole truth, and nothing but the truth? All right, please be seated.
Can you please state your full name, spelling your last name to the jury?
Sure. Richard Tracy, T-R-A-C-Y,
And where are you currently employed?
the New Hampshire Attorney General's office.
In what capacity?
I'm the chief investigator.
Dick Tracy broke that post down with me word for word, and never once did I say I was threatening to kill anybody. And at the very end, he turned around and said, I'll make some phone calls. It's all on the tape. I can play that tape right now, and that's for an instant dismissal because the AG's office knows what that post meant exactly.
She's been asking some questions about being able to play a recording. Are you going to be objecting to her?
Yes. We do not intend to play the tape, but I do have a few questions about that interview.
All right, so you may be eliciting some of what she said.
Correct.
So that does change the game.
Can I play?
So it depends on what they elicit and then what else is on that tape. And the only people under the rules of evidence, the state can offer it if they choose to as a confession, or they can choose not to offer it. Unless another situation arises that makes it admissible on its own, you simply cannot get up there and play the tape. You can testify about your side of the story and make reference. You can testify about having that interview.
The state would seek an order precluding the defendant from offering any statements that she made during her interviews with investigation. And also order the defendant not to make any comment about the court's order or the state's decision not to ask any questions about that of the investigator. Thank you, Your Honor.
Are you for real? For them not to allow me to.
Hold on, that's not quite the issue. It's their choice whether they want to admit the statements that you make. As I explained earlier, the statements that you make outside of court, when they're offered by the state, are not hearsay. So they could do it. They're choosing not to. Now, they do so at their own risk, because if the jury finds out what it was that you said to them, that may hurt their case. But what you're not allowed to do through Investigator Tracy is to ask him, didn't I tell you X? Or could you tell the jury what I told you in that interview?
If I take the stand and testify, can I say it's all on this and offer it as evidence?
You can say it's there. Whether you can offer the tape depends on what other issues develop.
The state would object to, if Ms. Elwood decides to testify on her behalf, she can say what she meant in her post, but she can't say, I told Dick Tracy, this is what I meant. That would be offering hearsay.
It depends on what she actually offers. I understand that you object.
Okay, thank you, Your Honor.
These are Facebook posts that you received on February 7, 2017.
Yes, they are.
And after you learned of the Facebook post, did you conduct an investigation?
Yes, I did.
As part of your investigation, did you attempt to locate those posts on Facebook?
Yes, I did.
Were you able to see the posts?
No, I was not. It appeared they had been taken down.
Did you obtain additional Facebook records of Ms. Delphico during your investigation, aside from the ones provided by Ms. Ducharme?
Yes.
From where?
From Facebook Incorporated in Menlo Park, California.
So how did you obtain all of these posts through the AG's office?
We obtained them through, or I obtained them through Facebook Incorporated directly.
Did you just call up Facebook and get them, or did you have to take out a search warrant?
Yes.
You took out a search warrant? Was I notified of that search warrant?
I don't know if you were or not.
Wouldn't I be told and be served?
What's that?
Wouldn't I be served a search warrant if I was told that there was a search warrant? I'd be served a search warrant.
If I came to your house to search your house, I would show you a copy of the search warrant.
So how does that work with Facebook? Not all those posts, it's not even showing if they're private or public. It's been made to my attention a lot more private by people that are sitting here with their name exposed. So again, is there a special name for a search warrant when the person that you're searching has no knowledge of it?
There are ways to seal a search warrant. I don't know. I don't know off the top of my head if this was done in this particular case or not.
Was I ever served a search warrant to go through my Facebook page?
No.
So you,
Do you recognize these?
Yes, I do.
What are they?
Those are some of the Facebook posts that I had received from Facebook Incorporated. They came, it was an entire package that I reviewed.
Investigator Tracy, can you see that?
Yes. On my page, I went off on that freaking judge today. I only posted the really good part.
State's Exhibit 5B.
If you want, share me telling Anderson off on your page, let others know this shit is real.
5C.
My case was thrown out.
5D.
So, Diane Lyons, I've been saving this one. So my ex is in contempt twice, tells the judge he never received a date and walks. Mike goes through the exact same thing and is arrested. Court corruption.
5E.
And you who think I'm crazy, no, I'm not. These judges are so paid off, it's sickening.
5F.
So after reading my decision, I can safely say that judge is fucked. The last line alone with him saying the credit union can't be held responsible, question mark.
5G.
I also need to tell everyone how corrupt Anderson really is.
H.
Whoever is monitoring my Facebook Since you understand my stress level, think you can give me a massage for my birthday? Smiley face. And for your little brain, the AG's office really doesn't care that I'm a witch. Ha ha ha. Get a life, loser.
Aye.
The whole story by Senator Kevin Avard. Still fighting for my house against a corrupt bank.
At this time, Your Honor, the state has no further questions for investigating Tracy.
All right,
So you're aware of the post. Did you call me about that post?
Yes.
Did you question me about that post?
Yes.
Did we go through that post, aisle through aisle on that post?
Yes.
Did I give out any kind of
Objection, Your Honor.
Did I give out any kind of response to you that you felt that it was a threatening post?
Objection, Your Honor.
so that's not relevant.
That's not relevant. When we went line to line through the post, at that time, did I express my religion of being with
Objection,
God?
Your Honor.
So that's hearsay. So that objection is.
Well, it was a conversation.
Objection.
No.
Did you find it threatening?
Objection, Your Honor.
So that's the statement.
That was the thing too?
Yeah, his opinion on whether it's threatening or not is not relevant. That's the jury to decide.
When we went through the post together, did you find any of it threatening to the point where I had to be arrested immediately?
Objection, Your Honor.
That's overruled. I think that's a fair question. In other words, did he take any action as a result?
Exactly. Did you take any
Against you
action the
directly.
second you saw that post and right after you spoke to me?
I did not arrest you that day, no. Did I take action? I continued with an investigation,
And
yes.
how long did that investigation go on for before action was taken?
Several months.
What, several months?
Several months, maybe a year?
Objection, Your Honor.
Or was there anything else on there threatening, like?
I didn't come across anything that rose to my level where I felt like I needed to take action to either alert another law enforcement authority that, hey, we got a potential problem here of a threat against an individual in your community, or anything that I felt that I needed to take action on.
I think I'll just leave it at that.
All right.
Thank you.
So you sit down and thank you.
Thank you.
We have no further questions, Your Honor.
All right, so ladies and gentlemen, at this time, the state has rested its case, which means it has not attempted to present any further evidence at this point. So what I do at this point.
I had waited on her a couple of times at the counter.
I have never had any dealings with her.
Just so Tuco, because the state has rested, you have an opportunity to make any motions to dismiss the case. At this point, you wish to make any such
I was just gonna make that motion. Your Honor, the state doesn't have any proof that I was a threat and that I made a threat before it's about accusations. I very, very, very clearly stated that it was nothing more than a wicked post, and I've been asked the honor to please find me not guilty at this time and dismiss this case.
I mean, did she get time to think and reflect and to consider what she wrote? This wasn't some outburst or spontaneous. That supports that she acted purposefully when she made those statements. She had to get behind keys, hit enter, type out each one. So that supports that she purposely intended to threaten the victims in this case and retaliate. The time and circumstances.
But wait, the fact that she typed it is evidence.
Well,
That it is a threat.
Well, I'm so sorry, that she acted purposely. Let them all die and suffer. The judges in that
Wait,
document.
how is that a threat by her? Let them all die and suffer.
When you
I
read,
mean, that doesn't mean I'm going to kill them. Just
well,
all I'm doing. I mean, if I disagree with you and I say, I hope you die, or shall you rot in hell, or something like that, doesn't mean I'm going to do anything. It just means I wish harm on you. That doesn't mean I'm going to do anything.
well, in this type of case, we don't have to prove that she actually intended to carry out the threat, but that the threat was
Has to
made.
be a threat to commit a crime.
Right, so when you read all three of the posts together in conjunction, she's saying, let them all die and suffer. Then she's stating her targets, the judges and that fucking attorney are so next, so next. And then again, you take that into consideration with, I am capable of killing you off. Don't ever cross me with corruption and greed. And I will say to Your Honor, the case law is pretty solid on the fact that when there is a dispute of whether a statement constitutes a threat or not, it is for the trier of fact for the jury to determine whether or not a statement constitutes a threat. A reasonable juror could find her guilty of these crimes, and thus the court should not dismiss it at this time.
So if you go to your response.
I trusted a bank, I trusted the judges, I trusted everyone to see the truth. And no one saw it. So I got aggravated. And I started videotaping, and I started doing interviews. And I got out of hand some days. I got emotional. I lost my son. I didn't see him get a license. I didn't see him go to prom. I didn't even see him graduate. The bottom line is I didn't threaten anybody. I didn't write on anyone else's page. I wrote it on my own. I took it down. I didn't go to any other organization. I didn't go to any other one's page. I didn't do it. It was all on my page. My page.
The Supreme Court requires me to analyze only the evidence that's been presented in this case to this point, and I am required to analyze that evidence and all of the rational inferences from that evidence in the light most favorable to the state at this point in the case. And then after assessing all of the evidence, my obligation is to determine whether any rational juror could conclude guilt on these charges. This is not an expression of my opinion whether you're guilty or not guilty, just whether a rational person, if they viewed all of the evidence in the light most favorable to the state and every reasonable inference in the light most favorable to the state, could they conclude guilt? In all candor to you, Ms. Del Fuego, I think it's a very close case at this point. It's a difficult case for the state. But I also, I have to keep in mind that I know what you said to Investigator Tracy back in March of 2017. This jury yet doesn't know that. So I know what your explanation is. The jury doesn't know, except for your opening statement, fully what your explanation is. I have to process that out of my own thinking. I can't take that into account because it's not evidence in the case yet. The first two posts in and of themselves, I do not think are threats to commit a crime. But when those two posts are read to the third post, and the language is isolating the language, but I am also just as capable of killing you off. When you read that in the context of the comment of so next, and let them all die and suffer, granted, they're not, to me, they're not the most clear threats in the world, and they could be interpreted as just venting. They could be interpreted as wishing ill will to the judges and to Attorney Gallant. But that's not my choice. That's not my decision. My decision is, could a jury read it in such a way that you are threatening and harming? And I think that they could. I'm not saying they will. I think that they could on this evidence. Like I said, it's a close case, but I am going to at this point. All of the other elements of the offense, I think, have been met. I think there's enough evidence there. The fact whether these are threats or not, that's for the jury to decide. I want to make sure that you understand that you have the absolute right under the Constitution, the Fifth Amendment, right not to testify. Do you understand that? If you chose not to testify, I would instruct the jury that they could not hold your choice not to testify against you in any way in reaching their decision. Right. Keeping that in mind, your right not to testify and the instruction that I would give to the jury, and understanding that the jury will be allowed, if you do testify, to assess your credibility and use your testimony against you or for you, however they choose to use it. Is it still your choice to testify?
It is.
All right. Do you swear that the testimony you're about to give to this jury will be the truth and the whole truth under the penalties of perjury?
I do.
Right. Please be seated. And I just simply ask you to state your name, spell your last name, please.
Janet Delfugo, Delfugo. So I'm gonna represent myself and my own witness. I did write the Facebook post. I'm not denying that I never did. I was able to speak with Dick Tracy about this post shortly after, like I said. We went through this post line by line. And I explained to him that, yes, I am a practicing Wiccan, and I'm also a Reiki master, and I work with energy. I practice energy. I'm also a hospice nurse, so I use energy a lot when people are passing over. And that post meant absolutely nothing more. When we went line by line, what it meant, and the whole post meant karma. Killing you off, and Dick Tracy knew this. There's a CD about that.
Objection, Your Honor. You read them?
Right, so ma'am, yeah, just try to get your own testimony with regards to the interview with Mr. Tracy.
Okay. So I had an interview with Mr. Tracy about it, and we went over it line by line, and he said, what the heck is killing you off? And as I quoted,
Objection, Your Honor.
Just give your testimony as to what, you
I
can say what you
as I quoted.
yeah, you can tell him, you can tell the jury what he asked you,
Okay.
but then you just need to give your testimony as to what it meant.
Okay, he asked me what it meant, so we went through it, and I told him the lines, what everything meant. It was my sister, my uncle, it was about testimony, about how they never even met my kids, but yet my ex-husband called to testify against me to get my oldest away from me, tried to get my youngest away from me, didn't get it. Next, so next, meant because of the post that you read where it said how everybody got sick. I looked at that as karma because I took all the negativity out of my house and away from my family, and I sent it back to them because they sent it to me. And that's how I feel that they are now suffering through their own thing and their own deaths because they're now no longer sending their energy to me, which would be negative energy. And then it says, so next. Well, with all the negative energy that I was dwelling through in the family court and in just the regular superior court, I wanted to be in that negative energy from that point on. So I was pushing the negative energy away. So when it says I'm capable of giving you the shirt off my back and healing your diseases, I'm a Reiki master, which means that I can work with my hands, and I don't even know if you people know what Reiki is. I'm a master of over 20 years. I learned Reiki from one of the original people that brought it to this country because they said I was a natural healer. I was given this gift for free. I'm capable of curing your diseases. I've done it. I'm also capable of killing you off. I never said I was capable of killing someone. I never said I was capable of murder. I'm not capable of that. I'm a hospice nurse. I cry when my patients die. Even after 35 years, I still cry. I said I was capable of killing you off. Don't cross me with your corruption and greed. And I told Dick Tracy that meant that I was setting the white light up around me and I was sending them back all of their negativity that they sent me. And everything they were doing to destroy me and my family. And that's what that Facebook post meant. And for a whole year they investigated me. I thought it was over after that post. Nobody ever said another thing again about that post. It never got brought up. None of the judges, they saw me, they heard cases, I got angry, they got whatever. I mean, it was heated. Not gonna lie, it got heated. This all started when I was 47 years old. I never even had a parking, well, I may have had a parking ticket. But I never had anything bad. I never did anything bad. I've been a nurse since I was 15.
Sure. Next.
So back to the post. I was 47 years old when all of this started, and all I was trying to do was just vent. Through that venting, I was able to meet a lot of different organizations and realize that I wasn't so alone anymore and I wasn't so secluded. And I came to realize that I wasn't the only one in the world that was going through this, that this is actually a worldwide problem that I was going through and the different elements that I was going through with this. there was more to this than I could handle or I could realize because I'd never been through something. I mean, I've only been married once, and it was just to this one person, and that was enough. So it was a learning experience, and I handled the learning experience very badly. I thought I had the right to freedom of speech and freedom of religion when I wrote it. I didn't think of the consequences. I didn't realize anyone was watching me. My Facebook post is open. I didn't think I was an important human being. I thought I was just another person, and I didn't think anything of it. I had no idea. When they contacted me on it, I stopped. I thought it went away. Apparently it didn't. And here we are. All I can say is, like I said, I went through it with Dick Tracy, and nobody thought this was a threat back then. I don't understand what's happened. I just don't.
The jury will disregard that last.
I just don't get what happened because at the end of the conversation with Dick Tracy, something else was completely said, and he never read up.
You can't say what was said. Okay.
I won't say what was
All right.
Another subject was completely brought up that didn't even relate to the post because, like, we had talked, that you heard, we know each other. And I thought it was over. I just thought it was over. That's all I have to say.
You knew it was wrong to post those statements, right?
At the moment I posted them, I wasn't thinking anything. I knew it was wrong after, and that's why I took them down voluntarily.
And you were angry.
I was sad. I was hurt.
You were angry at Judge Weaver.
I was sad and I was hurt at the whole entire situation. I was hurt at the system. I was just pulling out the 3 people I had to deal with within the system. I was angry and hurt at the whole system.
And when you posted your other statements, though, against the judges and saying you were corrupt, you were angry at them then. Is that fair to say?
I was hurt. I felt like the judicial system that I grew up around was supposed to protect me, and I didn't feel like no one was protecting me.
Okay. And so you posted those things and said those things like the judges are corrupt, right? And the judges are a bunch of pompous asses. You're saying you posted those out of hurt?
Yeah.
You agree that those are angry words?
I'll agree that I'm a Boston Italian redhead that has a very colorful vocabulary.
Would you agree that you have a temper?
Yes.
Okay. You were also angry at Attorney Felonies in that one.
Him I was angry at because I felt that anybody could change this and make it right, and they refused to.
Okay. Just give me 1 minute.
Okay.
You meant those posts in the sense of an eye for an eye, is that correct?
That's a Catholic saying in the Bible. Just because I'm Wiccan doesn't mean I wasn't raised Catholic. My grandparents are from Italy. Trust me, there is no one stronger Catholic than an Italian Catholic. I just never told anybody that I am Catholic, but I just practice Wiccan. An eye for an eye is what is said in the Bible. I don't know how many Bibles, but I know it's in the one that my grandmother had.
So is the answer yes? So
Yes.
if that's what you meant, supposed to be an eye for an eye?
Well, it's not so much an eye for an eye, it's more, that's Catholic. Wiccan is, people do bad things to you, so it comes around, goes around, and there's a way of blocking that negativity and sending it back. So it's not so much, all right, you did something bad to me, I'm doing something bad to you. It's you're doing something bad to me, and I'm not going to deal with it, so I'm going to push you away from me. I'm like turning the other cheek, except I put up an energy wall.
Didn't you explain that the posts were meant as an eye for an eye, that was one of your explanations for the post?
I used it in the terminology on the thing as a whole with Dick Tracy because I had to go into further terminology with him about the light. I mean, not to put down a man, but most men don't understand when I'm talking about energy and karma. A lot of women don't either, but let's be real here. Men really don't focus on that kind of stuff. So I used it as a terminology that he probably would have grown up with in the Bible.
I understand. Your testimony is that you took the post down within a couple of hours. Is it possible you left it up for an entire day?
No, because I'm almost 99.9% positive that I remember because someone called me and said, oh my God, what have you done? Take that down. That's wrong. What is going on? What has happened? And I said, I'd already taken it down.
Okay. You took the post down before someone called you and said it was wrong?
Yes.
Okay.
But then she had called me because she said that it was out of character for me to post something like that. And she wanted to know what was going on because she knew about my stress level.
Okay.
So, anything further from the defense at this point?
I could present that, like I said.
Why don't you come on over a second? So folks, at this time, the defense has also rested her case. So the evidence in this case is complete. Given the hour, there isn't time to go into closing arguments and final instructions today. So we'll return tomorrow at 10 o'clock for closing arguments, my final instructions, and then after that you'll have the case for deliberation. Good morning, ladies and gentlemen. At this time, we're going to be having the parties' closing arguments, which will be followed by my final instructions. Ms. Delfico, you go first, so your closing argument.
The judge let me say something, and I'm going to kind of quote it as perception. It's about perception. And the perception part about this is, I've talked over and over again how I had all these interviews from the AG's office, what people were saying right after. I kept quoting people on it. The AG's office called me right after the post. What is this, Janet? We know you, we know you're going through a hard time. We know, you've been here. Dick Tracy said, we go back. I complained about the bank, I complained about the equity loan, I complained about the way I was being treated by everybody. Why wasn't anyone helping me? I went to every agency, man, why aren't you helping me? Why am I losing my house? Why am I losing my kids? What did I do? I thought it was cleared up, I thought it was over. His last words were to me, I'm gonna call the bank. I kept going back and forth to court. Finally, I just got up, like Judge Weaver said, and I walked out. And I never went back again. I was like, I'm done. I can't do this anymore. I'm at my breaking point. That was months after I'd written the post. I didn't think anything of it. They'd already called me about it. It was done. It was over. So why was there a whole year investigation? Why didn't they just say, we saw the post. What did you mean? What did it do? Why don't do it again? Instead, they take out search warrants and they follow me for a year. And here we are, 2 years later. Here we are, 2 years. Not 4 or 5 months, not 6 months, not even a year. 2 years later, I wrote the post. I was distressed that day. There's no excuse for that. I wanted it to be calmer. I wanted the energy to stop. I wanted the negativity to stop. I said that yesterday on the stand. So I still need the answers. I still need to know why, if they thought it was okay for me to keep going, why am I here today? And those are the answers I don't have. Those are the answers I'm going to need at some point. Someone needs to answer to me about this. I didn't go kill anybody. I didn't harm anybody. I didn't threaten anybody. I said, Karma did this to you. And then I said, next. Karma, next. You just freaking wait.
You might feel sorry for the defendant observing her behavior in this courtroom over the course of the last 2 days and today. During her closing argument, she's been tearful, sometimes seemingly remorseful. But as the defendant seemed to just acknowledge and the evidence showed you, that is not how she acted in Judge Weaver's courtroom. That is not how she acted in Judge Anderson's courtroom. And that is not how she acted towards Clifford Gallant. What the evidence shows is that Janet Delfuco had waged a war against those judges and Granite State Credit Union for more than 2 years. She repeatedly attacked them on social media, calling the judges and Cliff Gallant corrupt. She used foul, ugly language. She illustrated a Facebook post about Judge Weaver with a pornographic photo. The defendant is entitled to choose the vulgar words she uses. She can tell Judge Weaver to suck her ex-husband's balls. The defendant is entitled to use words that criticize. She can call the judges and Cliff Gallant corrupt. She's entitled to use words that insult. She can say that Judge Anderson is a pompous ass. She can say that he's fucked. But she is not entitled to choose words, to use words that threaten, because that, ladies and gentlemen, is a crime. And that is why we're all here today. Let them all die and suffer. That judge, those judges and that fucking attorney are so next. Next is Weaver, Anderson, and Gallant. I will give you the shirt off my back, but I'm also just as capable of killing you all. Don't ever cross me with corruption and greed. Her words, there are 5 charges. 4 of them concern the judges. And with regard to those 4 charges, Judge Howard will tell you that we have to prove these elements. That the defendant purposely threatened bodily injury or threatened to commit a crime against a member of the judiciary in retaliation for action taken as a part of the government official's duties. There's really only 1 charge for each judge, but it's charged in the alternative. That is 2 different ways. So you can find that the defendant's words in her posts were threats either of bodily injury or threats to commit a crime, or both. There's 1 charge concerning attorney Clifford Gallant, and Judge Howard will tell you that in order for the state to prove to you that the defendant committed the crime of criminal threatening, we have to prove beyond a reasonable doubt these elements: that the defendant threatened to commit any crime against the person of another with the purpose to terrorize. And that's how the defendant's victims understood her threats. Each victim was concerned for his own safety or the safety of someone he worked with. And each victim believed that as a result of the defendant's threats, that it was possible that the defendant might actually cause them harm. We also have to prove to you that Judge Anderson and Judge Weaver were members of the judiciary, and there's no question about that. Both judges told you that they are judges. They told you how they became judges. They told you that they were employed by the judicial branch of government, and the defendant doesn't dispute that element of the crime. We have to prove to you also that the defendant retaliated. She threatened the judges and attorney Gallant. We're here because what the defendant did on February 5th was a crime. And the evidence, including the defendant's own testimony, establishes that beyond a reasonable doubt. We ask that you find the defendant guilty of the crimes as charged.
A threat is a statement of intention to inflict harm, in this case to commit a crime against a judge. In this case, the alleged threat involves statements by Ms. Delfuga. You have heard testimony that she believes such speech was protected by the First Amendment right of freedom of speech and freedom of religion. Generally, the First Amendment. Yes. Generally, the First Amendment protects the right of persons to speak and to practice their religion free from government intrusion. The First Amendment, whether speech or religion, does not give a person the right to threaten to commit a crime or bodily injury against another. In order to convict, you must find beyond a reasonable doubt that the statements were a true threat. That is, that Ms. Delfuga made the statements with the intent to commit a crime against a judge. The state is not required to prove that the defendant intended to carry out the threat, or that it was made directly to the judge, or that the judge was actually placed in fear as a result of the threat. Ambiguous or subtle language does not necessarily mean that the statement cannot be a threat. Whether the state has proved beyond a reasonable doubt that the language constituted a threat is for you to decide, just as you are to decide whether the state has proved all of the elements of the offense charged beyond a reasonable doubt. My understanding is that the jury has reached a unanimous verdict in this case. Is that correct?
Correct.
And is the jury unanimous on all 5 charges?
Correct.
At this time, I'm going to ask the clerk to take the verdict from the foreperson.
Okay.
Service to docket number 2182018 CR66, charge ID number 1457074C, alleging harm or threats to certain government officials by threatening to commit a crime against Judge David Anderson. How does the jury find the defendant guilty or not guilty?
Not guilty.
So say you all. Okay, service to the same docket number. Charge ID number 1457071C, alleging harm or threats to certain government officials by threatening to commit a crime against Judge Mark Weaver. How does the jury find the defendant guilty or not guilty?
Not guilty.
So say you all. In the same docket number, charge ID number 1457073C, alleging harm or threats to certain government officials by threatening bodily injury against Judge David Anderson. How does the jury find the defendant guilty or not guilty?
Not guilty.
So say you all. In the same docket number, charge ID number 1457072C, alleging harm or threats to certain government officials by threatening bodily injury against Judge Mark Weaver. How does the jury find the defendant guilty or not guilty?
Not guilty.
So say you all. In the same docket number, charge ID number 1457075C, alleging criminal threatening. How does the jury find the defendant guilty or not guilty?
Not guilty.
So say you all. Thank you. You may be seated, sir.
All right, thank you, ladies and gentlemen. At this time, your service in this case is complete. I would ask you when you retire to the deliberation room if you could wait just a few moments so I can thank you personally for your service.